They told you that you needed their permission to exercise a right that was written into the founding document of this nation. They made you fill out forms, wait in lines, pay fees, pass tests, and beg a government bureaucrat for a slip of paper just to exercise a right that the Constitution says shall not be infringed. And then on June 10th, a federal court looked at all of that and said, enough. A court just ruled that gun permits in their current form may be constitutionally dead. And somehow, some way, the people who are supposed to be telling you this story are either whispering it into the void or spinning it so hard you'd need a gyroscope to follow the narrative. This is the story of what just happened, why it matters more than almost anything else happening in this country right now, and what it means for you, the ordinary American who's been told for decades that your rights are negotiable. They are not. And a court just said so out loud. If this kind of reporting matters to you, the kind that doesn't flinch, doesn't spin, and doesn't wait for permission, hit subscribe right now and turn on notifications because we are just getting started. What the ruling actually says, let's be precise here, because precision is what separates journalism from propaganda, and right now this country desperately needs the former. The ruling that dropped on June 10th didn't come out of nowhere. It came out of a legal landscape that has been shifting seismically since the Supreme Court handed down its landmark New York State Rifle and Pistol Association v. Bruen decision back in 2022, a ruling that fundamentally changed the test courts must use when evaluating gun laws. Before Bruen, courts were playing a balancing game. They'd weigh the government's interest in public safety against the individual's Second Amendment rights. And more often than not, the government won. Bruen blew that up. And the Supreme Court said that from now on, if the government wants to restrict your Second Amendment rights, it has to point to a historical tradition of similar regulation going back to the founding era, not to modern sensibilities, not to today's crime statistics, to 1791, to the world as it existed when the Bill of Rights was ratified. And that standard, applied honestly, is devastating to a whole architecture of gun permit laws that states have built up over the past century. What the June 10th ruling did was apply that Bruen standard directly to the permit requirement structure in the jurisdiction in question, and the court found it wanting. The court found that the government could not produce the historical record necessary to justify forcing law-abiding citizens to obtain government permission before exercising a constitutional right. Think about what that means in plain English. You don't need a permit to speak freely. You don't need a permit to practice your religion. You don't need a permit to refuse an unreasonable search of your home. Those rights exist as rights, not as privileges dispensed by bureaucrats. And this court said that the right to keep and bear arms deserves the same treatment. The permit regime, the fees, the waiting periods, and built into the permitting process, the discretionary approval systems that allowed officials to simply deny applications they didn't like, all of it came under the constitutional microscope, and it didn't survive the examination. Now, critics are already screaming that this is chaos. They're saying that without permits, dangerous people will flood the streets with weapons. But here's what they're not telling you. This ruling does not eliminate background checks. It does not hand guns to felons. It does not create some lawless frontier where anyone can do anything. What it does is remove the permission slip layer. The government is gatekeeper model that required you to prove yourself worthy of a right you already possess by birth as an American citizen. The people screaming loudest about this ruling are the same people who have been perfectly comfortable watching that gatekeeper system function with racial bias, class bias, and bureaucratic arbitrariness for decades. Funny how they only care about fairness when the ruling doesn't go their way. The history behind the fight. To understand why June 10th matters, you have to understand how we got here. Because permit requirements didn't fall from the sky. They were built, brick by brick, by legislatures that were often motivated by fear. And not always fear of violence, sometimes fear of who was carrying the weapon. The history of gun permit laws in America is, in significant part, a history of racial control. The earliest permit and licensing schemes in the post-Civil War South were explicitly designed to disarm Black Americans who had just been granted citizenship and constitutional rights. The establishment didn't want those newly freed citizens to be able to defend themselves, so they created systems that required government approval that would conveniently never come for the people those systems were designed to suppress. That's not conspiracy theory. That's documented history, and it's history that the Second Amendment community has been citing in court for years, with increasing success since Bruen opened the door. As the 20th century progressed, Permit requirements evolved and spread, sometimes for legitimate public safety reasons, sometimes driven by urban political machines that wanted control over who could and couldn't be armed in their jurisdictions. The result was a patchwork of laws that varied wildly from state to state. In some states, so-called shall-issue laws meant that if you passed a background check and completed a safety course, the government had to give you a carry permit, no discretion, no games. In other states, may-issue laws meant that local officials could decide, based on their own judgment, whether your need to carry was sufficient. And in those may-issue jurisdictions, wealthy, connected people got their permits without trouble. Ordinary people, especially ordinary people of color in major cities, got denied, told their need wasn't good enough, sent home without the protection they had a constitutional right to seek. The Supreme Court addressed part of this in Bruen, specifically targeting the May-issued discretionary system in New York and ruling it unconstitutional. But the broader permit requirement structure remained standing, waiting for the next challenge, and that challenge came. And it worked its way through the courts, brief by brief, hearing by hearing, with attorneys building a record showing that the founding generation did not have a tradition of requiring permits to carry or possess firearms, and that when the Second Amendment was ratified, Americans carried weapons as a matter of daily life without asking anyone's permission. And now, in 2026, that argument has prevailed in a significant federal court ruling. This is the culmination of a decades-long legal battle fought by people who believe that constitutional rights mean what? They say, the question is whether the rest of the country's legal establishment will respect that outcome or fight it every step of the way. What this means for everyday Americans? Here's where we get out of the legal weeds and into the real world, because that's ultimately what this is about. Not abstract constitutional theory, not courtroom victories that feel distant and academic. What does this actually mean for the person working 2 jobs in a city that's been gutted by crime, who's been trying for months to get a carry permit and keeps hitting bureaucratic walls? What does it mean for the rural gun owner who never understood why they needed the government's blessing to do what their grandfather did without a second thought? What does it mean for the single mother in a dangerous neighborhood who can't afford a lawyer to navigate a permitting system that seems designed to confuse and exhaust anyone without resources? It means that the constitutional right to keep and bear arms is moving closer to being treated like an actual right rather than a conditional privilege. And that matters enormously in practical terms. People who have been denied permits, sometimes for reasons as arbitrary as an official not liking the look of their application, may now have a legal foundation to challenge those denials. States with permit requirements that cannot survive the historical scrutiny the Bruen standard demands are going to face a wave of legal challenges. And the ones whose laws are most detached from any founding-era tradition are going to lose those challenges. The map of American gun law is being redrawn right now, and most of the media either doesn't understand what's happening or doesn't want to explain it honestly. There's also a safety dimension to this that the anti-gun media absolutely refuses to engage with seriously. Researchers, actual academics, not lobbyists, have found in multiple studies that legal gun ownership has a deterrent effect on crime, that areas with higher rates of legal carry tend to see certain categories of violent crime decrease, that criminals who by definition don't follow permit laws choose their victims based on perceived vulnerability. A society where law-abiding people can carry without jumping through government hoops is a society where the calculation for a would-be attacker changes. This is not a radical argument. It's a logical one, and it's one that gets drowned out every time a court ruling like this drops, because the narrative machine shifts immediately into fear mode rather than engaging with the actual evidence. Don't let the narrative machine do your thinking for you. And if you want reporting that gives you the full picture, not just the half that fits someone else's agenda, subscribe right now. Every notification you turn on is a vote against lazy. Agenda-driven journalism, the political firestorm. Now let's talk about the politics, because you cannot separate this ruling from the political environment it's landing in. We are in 2026, a midterm election year, and this ruling is a live grenade rolling across the floor of American political life. Every politician in the country is going to have to figure out where they stand, and the positions they take are going to reveal more about their actual values than almost anything they've said in the past. 2 years. On the right, you've got politicians who are celebrating this ruling loudly, framing it as a victory for constitutional freedom, talking about the Second Amendment in the same reverent terms they use for every other amendment when it's politically convenient. And look, on the substance of the ruling, they're not wrong. But let's be honest about the hypocrisy available on this side of the aisle, too. Many of the same politicians praising this ruling have been perfectly comfortable with surveillance states, with restricting other constitutional rights when national security is invoked, with warrantless data collection, with all manner of government overreach, as long as it wasn't the Second Amendment being squeezed. Freedom is apparently very important, right up until the government wants to do something those politicians agree with. That's not principle. That's selective outrage, and Americans deserve to call it out. On the left, the reaction has been predictably catastrophizing. Words like dangerous, reckless, and deadly are being deployed with assembly line efficiency. Politicians are holding press conferences, demanding legislative responses, calling for constitutional amendments, warning of bloodbaths in the streets. And here's the thing, some of the concern about gun violence in America is legitimate. The country does have a serious problem, but the solutions being demanded by these politicians consistently focus on the law-abiding gun owner, on permits, on restrictions, on making it harder for legal carriers to exercise their rights, while doing almost nothing about the illegal gun market that supplies the weapons used in the overwhelming majority of violent crimes. That is not a good faith approach to public safety. That is political theater designed to satisfy a base, not to actually protect anyone, and a court just called that theater out. Meanwhile, the moderate political class is doing what it always does, triangulating, hedging, waiting to see which way the wind blows before committing to a position. These are the politicians who will be on three different sides of this issue before the midterms are over. Who will cite the ruling when it's convenient and condemn it when it's not? Who have no actual conviction about the Second Amendment or about civil liberties more broadly? They're the most dangerous kind of politician there is. Not the true believers on either extreme, but the calculated nothing people who will say anything to stay in power and do nothing to actually govern. The media's failure to report this honestly. Let's spend some time on the media's role in this story, because it's a story within the story that deserves its own hard examination. The way major outlets are covering this ruling tells you almost everything you need to know about the state of American journalism in 2026, and none of it is flattering. The headline choices alone are revealing. Court strikes down gun safety measure. Ruling could put more guns on streets. Judges side with gun lobby. These are not neutral descriptions of a legal decision. These are editorials disguised as headlines designed to prime the reader's emotional response before they've read a single word of actual reporting. What you're not seeing in most of the mainstream coverage is honest engagement with the legal argument the court made. You're not seeing reporters sit down with constitutional law scholars who supported the ruling and give them the same column. Inches they're giving to the critics. You're not seeing the historical evidence, the actual founding era record that the court relied on. Explain clearly so that readers can evaluate it for themselves. You're not seeing the class and racial dimensions of the permit system that this ruling challenges, the ways in which permit requirements have historically fallen hardest on poor people and people of color, because that would complicate the preferred narrative. And the preferred narrative is simple. Guns are bad, restrictions are good. Anyone who challenges restrictions is dangerous. That narrative isn't journalism, it's advocacy. And the problem with advocacy disguised as journalism isn't just that it's dishonest, it's that it's strategically stupid. When you consistently frame one side of a constitutional debate as beyond the pale, as not worthy of honest engagement, you don't win the argument. You radicalize the people you're dismissing. You create a media environment where millions of Americans don't trust anything they read about this issue, because they've learned from experience that what they're being told is filtered through a lens that doesn't respect their perspective. The trust deficit in American media didn't appear out of nowhere. It was built story by story, exactly like this one. What good journalism on this ruling would look like is simple. It would explain the legal standard the court applied and why. It would present the historical record honestly. It would interview legal experts on both sides with equal rigor. It would examine the real-world implications, including the safety arguments on both sides, without predetermined conclusions. It would treat the readers like adults capable of processing complexity and forming their own judgments. That's not what's happening. What's happening is a coordinated effort to tell you what to think about a court ruling before you've had a chance to think about it yourself, recognize it for what it is, and then go find the information they're hoping you don't. What comes next? The legal and cultural battle ahead. So where does this go from here? Because a court ruling, even a significant one, is not the end of the story. It's a chapter. And the chapters that follow are going to be just as important as what happened on June 10th. probably more so for most Americans' daily lives. Let's talk about what's actually coming. First, appeals. The jurisdiction affected by this ruling is not going to accept it quietly. State attorneys general, city governments, advocacy organizations, all of them are going to throw resources at overturning this decision at the appellate level. That means this ruling may not take full effect for months or years while the appeal process plays out. Injunctions could be filed that pause implementation. Higher courts could uphold or reverse the decision. And ultimately, there's a real possibility, some would say a likelihood, that this issue winds up before the Supreme Court again, and the court has already weighed in on the Second Amendment twice in major ways. With Heller in 2008 and Bruen in 2022, a third major ruling, one that addresses the permit question directly and comprehensively, may be necessary to finally settle the legal landscape, whether this current court is willing to go there. And how far is one of the most consequential questions in American law right now? Second, state-level responses. Even if this ruling is upheld, individual states have enormous power to shape how it's implemented within their borders. Some states are going to comply minimally and find every possible workaround. They'll strip down their permit systems to the bare constitutional minimum while preserving as much regulatory infrastructure as they can. Other states will go in the opposite direction, using the ruling as an opportunity to fully liberalize their carry laws and eliminate permit requirements entirely, the so-called constitutional carry model that about half the states have already adopted in some form. The patchwork of American gun law is going to get even more complicated before it gets simpler, and that complexity has real consequences for people who travel across state lines and face a constantly shifting legal landscape. Third, the cultural battle, which in some ways matters more than the legal one, because laws can be changed, challenged, overturned, rewritten. But the cultural conversation about what the Second Amendment means, who it's for, and what kind of country America wants to be on this question. That conversation is happening right now in real time, and the outcome of that conversation will shape the legal and political landscape for a generation. And in that cultural battle, the quality of information people have access to matters enormously. Whether they understand what this ruling actually said, as opposed to what they're being told it said, matters. Whether they engage with the real arguments on both sides, rather than the caricatured versions each side presents of the other, matters. That's why this kind of reporting matters. Not because there's one correct position everyone should hold on the Second Amendment. Reasonable people disagree about gun policy, and that disagreement deserves honest engagement. But because the debate we're having in this country is being poisoned by bad information, by motivated framing, by media outlets that have decided their job is to tell you what to conclude rather than give you what you need to think, you deserve better than that. The stakes of this debate, public safety, constitutional rights, the relationship between citizens and their government, are too high for anything less than honest, rigorous, relentless reporting. June 10th was a hinge point. Something shifted in the legal architecture of American gun law, and the ripple effects are going to be felt for years. The politicians are already positioning. The lawyers are already drafting. The media is already spinning. And ordinary Americans, the ones this ruling actually affects, the ones who have been navigating permit systems and constitutional uncertainties and the daily reality of living, in a country with a complex and contested relationship to firearms, deserve to know exactly what happened, exactly what it means, and exactly what's coming next. That's what we're here to do. If that mission matters to you, if you believe that accountability journalism, honest constitutional reporting, and the refusal to be captured by any political narrative is worth supporting, then subscribe right now. Leave a comment telling us what you think about this ruling, where you stand, what questions you want answered, and because this conversation is just beginning, and your voice in it matters. We will keep watching, keep reporting, and keep refusing to pretend that everything is fine when it isn't. That's the job, and we're not done.